I will discuss Inventing the Future, an introduction to patent for small and medium-sized enterprises. Let's start with patenting abroad. Why apply for foreign patents? Patents are territorial rights, which means that an invention is protected only in the countries or regions where patents have been issued. In other words, if a patent has not been granted in a given country, the invention will not be protected in that country, enabling anybody else to make, use, import, or sell that invention in that country. Ibig sabihin, kapag ang isang invention ay ginawa mo sa ibang bansa at ito ay hindi na isyuhan ng patent, maaaring gamitin ito ng ibang tao, i-import or ibenta. Next question is, when should an application be made for patent protection abroad? The date of the first application for a given invention is called priority date. Any subsequent applications in other countries filed within 12 months of that date will benefit from this priority date. Where should an invention be protected? Because obtaining foreign patents is expensive, companies should carefully select the countries in which they require protection. Consider these key questions. Where is the patented product likely to be commercialized? What are the main markets for similar products? What are the costs involved in patenting each target market? What are the main competitors? Where are the main competitors based? Where will the product be manufactured? And how difficult will it be to enforce a patent in a given country? Dahil mahal nga ang pag-i-issue ng patent sa ibang bansa, ang mga kumpanya ay kinoconsider ang mga tanong na ito. Saan ibebenta yung product? Ano yung mga kaparehas na product? Magkano yung product? Saan nakabase yung mga main competitors? Saan na manufactured yung product? At gaano ito kahirap i-enforce? How can an application for patent protection abroad be made? There are three main ways of filing for foreign patents. We have the national route, regional route, and the international. In national, apply to the National Patent Office of each country of interest by filing a patent application in the required language, complying with the national formality requirements, and paying the required fees. This path may be very cumbersome and expensive for multiple countries. The regional route, when countries are members of a regional patent system, protection with effects in the territories of all or sought by filing an application with the relevant regional office. The regional patent offices are the African Intellectual Property Organization or OAPI, the African Regional Industrial Property Organization or ARIPO, the Eurasian Patent Organization EAPO, the European Patent Office EPO, and the Patent Office of the Cooperation Council for the Arab States of the Gulf or GCC Patent Office. And for the international route, if a company wants to have the option of protecting an invention in the member countries of the PCT, it should consider filing a PCT application. To do so, at least one inventor must be a national or resident of a PCT contracting state, or the business must have an effective industrial or commercial presence in one of these countries. The next topic is commercializing patented technology. How can patented technology be commercialized? A patent on its own is no guarantee of commercial success. It is a tool that enhances a company's capacity to benefit from its product or technological innovation. In order to provide a tangible benefit, a patent needs to be exploited effectively and will generally make money only if the relevant product or process is successful. How do you take a patented product to market? Commercial success therefore also depends on a range of other factors, including the design of the product, the availability of financial resources, the development of an effective marketing strategy, and the price of the product in comparison with competing or substitute products. Can a patent be sold? Yes. Selling a patent is called assigning it. and it will transfer ownership of the patent to another person. Such a decision must be considered very carefully. Licensing a patent instead of assigning it means that the rights are rented to others in return for royalty payments. Licensing can be a very financially rewarding strategy for that reason. Assignment, on the other hand, commonly means that an agreed-upon payment is received once, with no future royalties regardless of how profitable the patent ends up being. How is a patent licensed? A patent is licensed when the owner of the patent, which is the licensor, grants permission to another, which is the licensee, to use the patented invention for mutually agreed purposes. In such cases, a license agreement is generally signed between the two parties, specifying the terms and scope of the agreement. What royalty rate can be expected? In licensing transactions, the owner of the right is generally compensated through lump sum payments and or recurring royalties, which may be based on sales volume of the relevant product for unit royalty or on net sales-based royalty. In many cases, payment under a patent license is a combination of a lump sum and royalties. Hence, what is the difference between an exclusive, non-exclusive, and sole license? There are three types of license agreements, depending on the number of licenses that will be followed to use the patent. In exclusive license, a single licensee has the right to use the patented technology which cannot even be used by the patent owner. Sa exclusive license, yung isang licensee, siya lamang yung may karapatang gumamit ng patented technology. Samantalang yung patent owner, wala siyang karapatan. In sole license, a single licensee and the patent owner have the right to use the patented technology. Sa sole license, yung isang licensee at saka yung patent owner, parehas na silang may karapatang gumamit ng patented technology. And lastly, sa non-exclusive licensee, several licensees and the patent owner have the right to use the patented technology. Higit sa isa o maaaring madaming licensee at saka patent owner ang may karapatang gumamit ng patented technology. Within a single license agreement, there may be provisions that grant some rights on an exclusive basis and others on a sole or non-exclusive basis. Should you grant an exclusive or non-exclusive license for your patent? It depends on the product and on the company's business strategy. For example, if the technology can become a standard that is needed by all players in a specific market to perform their business, a non-exclusive, widely held license would be the most advantageous. When is the best time to license an invention? There is no best time to license an invention, as the timing will depend on a variety of factors. However, for an independent entrepreneur or inventor, it is often advisable to start the search for licensees as early as possible in order to guarantee a revenue stream that can be used to cover the cost of patenting. There is no need to wait for the patent to be granted. More than the right time, it is critical to find the right partner or partners to generate profits from commercialization of the patented invention. How can permission be obtained to use a competitor's patent? This may not always be easy or affordable. However, how can permission be obtained to use a competitor's patent? This may not always be How can permission be obtained to use a competitor's patent? This may not always be easy or affordable. However, if the competitor is also interested in the patents of the company, cross-licensing may be considered. Cross-licensing is very common in industries where a number of patents covering a wide range of complementary inventions are held by two or more competitors. Now, let's move on to the next topic, which is enforcing patents. Why should patent rights be enforced? If a new patented technology is brought to market, competitors may try to make products with technical features that are identical or very similar to that product. not having to spend the same resources or take the same risk, competitors would have an advantage and be able to make a similar or identical product at a cheaper price that could put unfair competitive pressure on the patenting owning business. Who is responsible for enforcing patent rights? The main responsibility for identifying and taking action against infringers of a patent lies with its owner. Of course, educating employees on how to identify infringers can help a business in monitoring the marketplace. Nevertheless, a patent owner is responsible for monitoring the use of its invention in the marketplace, identifying any infringers, and deciding whether, how, and when to take action against them. Independent inventors and SMEs may decide to shift this responsibility or part of it to an exclusive licensee. What should you do if your patent is being used by others without your authorization? If the patent owner believes that others are using their patented technology without authorization, then as a first step, information must be collected as to who is infringing, how they are doing it, and the effect of the infringement on the patent owner's business. A patent lawyer should be engaged to assist in analyzing these events and deciding what to do about the infringement. What are the options for settling an infringement claim out of court? If there is a contract with the infringer, first check whether there is a clause calling for mediation or arbitration. These are alternative and often less costly forms of dispute resolution than suing in court. Even if there is no such clause in the contract or no contract at all, it may still be possible to take advantage of these private procedures, so as long as both parties agree to submit to such a procedure. Arbitration is generally shorter and less expensive than court proceedings, and if the other party is foreign, an arbitral award is more easily enforceable internationally. An advantage of mediation is that the parties can keep the process informal and find an agreed solution that takes account of their interests. As such, it can help to preserve good business relations. The World Intellectual Property Organization Arbitration and Mediation Center provides non-profit services for alternative dispute resolution. For more information on arbitration and mediation can be found at www.wipo.int/amc. And that's all for the discussion. Thank you.